Hi, I'm Emily, and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in New York and Connecticut. My question for Attorney Murphy today is, what does no-fault divorce mean?
So no-fault divorce in Connecticut specifically means that essentially if you want a divorce in Connecticut, you get one. It used to be the case that in both Connecticut, but also in many other states, it used to be the case that you had to prove something specific in order to obtain a divorce. There were other causes of action, some of which still exist in the law, such as abandonment or adultery or fraud or cruel and inhuman treatment. And you had to prove one of these things in order for a court to grant you the divorce. In Connecticut, the vast majority of divorces are obtained by one party or the other, indicating that there has been an irretrievable breakdown of the marriage. So basically, if one party is willing or prepared to testify that the marriage has broken down irretrievably without the possibility of reconciliation, then a divorce would be granted. That's what no-fault divorce means.
So, does no fault mean that fault doesn't matter at all?
That's an interesting question and one I field a lot. Fault, or for lack of a better term, the reason for the breakdown of the marriage is actually something that's built into both the statutory language for division of assets and also for the award of alimony. So in order for a court to decide what someone would receive from a divorce by way of either alimony or the asset division, a court would consider a whole host of things based on the testimony and the evidence presented. And those sorts of things would be the length of the marriage, the age, the health, the station in life of the parties' occupations, their amount and sources of income, their earning capacity, their skills, the size of the estate, any liabilities they might have or specialized needs that they have or the children have, or the opportunity for each of those parties to go out and acquire assets by some other means, and how they contributed to the assets during the marriage. So these are all things that a court can weigh and consider. But in both of those statutes, one of the factors is also the reason for the breakdown of the marriage. So in other words, a court can and likely will listen to evidence from one side or the other as to how the parties got there, and in other words, why the parties are getting divorced, and then weigh that along with the other factors in deciding how much that's going to impact either the alimony award or the division of assets award. In any case, a party should always discuss with a lawyer to what degree that lawyer thinks that a breakdown of the marriage either may or may not materially affect or impact the outcome of your divorce.